Please, my lord.
Yes, please.
Worship, hearing item number 16 to 19. Worship, I'm mentioning on behalf of Ms. Shokre, AG. She's indisposed. Can you release the matter after 1 week?
On the last occasion, I think we had passed some order that any adjournment will be subject to post.
She's in receipt.
Mr. Kiangami makes a mention on behalf of MSV Sokri, the learned additional advocate, the learned, she appears as, okay, this is repeating, the learned additional advocate general. And 6, adjournment of the case for a week. The learned additional AG is indisposed. Prayer is allowed, listed on. Second is Wednesday. Listed on is 2/8/2023. Stop. It is made clear that no further adjournment shall be granted to any of the parties. Okay.
Worship, I have seen the prayer in item number 21 of Ms. Shokre.
Please, my lord. If
Yes.
you can come up after 2 weeks, then in that case, my lord. Because on next Wednesday, my sister-in-law is getting engaged.
Okay.
So,
On the prayer of the learned counsel for the parties, listed after 2 weeks.
deeply obliged.
Worship, item number 11, 12, and 13. Worship. If these may come up after 2 weeks, worship,
You're for the
and for the state worship.
Mr. Kiangami, the learned PP, 6, adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
Obliged, your worship.
Next, Lordships.
Yes.
Lordships, I'd like to mention item 10, Lordship. Lordship, I'm making mention on behalf of my senior Mr. P.P. Poe, counseling for the response number 1 to 11. Lordships, my senior is not doing well, Lordship. So, Lordship, may kindly let us come up for 2 weeks, Lordship.
For the respondent number,
1 to 11.
Mr. Prosecco makes a mention on behalf of Mr. P.P. Bol, the learned counsel for the respondent number 1
1 to 11,
to 11,
Lordship.
and 6, adjournment of the case after 2 weeks.
Lordship.
Prayer is allowed, listed after 2 weeks. Okay.
Otherwise, Lord.
Yes.
Please, Lordships.
Yes.
I would like to mention here in item number 14. Lordship, let this matter be reviewed after 2 weeks. Lordship.
You are the counsel for. Oh, 14. This is 14 along with 15.
Yes, Lordship. I'm reading item number 14. Criminal Appeal 6 of 2020. I'm the appellant here.
You are the appellant.
Yes, in item number 14.
Okay. What about 15? Okay. You are 15. Mr. So-and-so, the learned counsel for the appellant, in CRAPL 6/2020, 6 adjournment of the case after 2 weeks. Stop. Prayer is allowed. Listed after 2 weeks. Okay.
Right, March of launch. That is, Your Lordship, I
Yes.
have to mention item number 20. Only this matter may be listed after a week. I've taken the consent from the petition.
20.
Yes, Your Lordship.
You are the counsel for the
Respondent 3 and 4, Your Lordship.
respondent 3 and 4.
Yes, Your Lordship.
Mr. So-and-so, the learned counsel for the respondent number 3 and 4. 6 adjournment of the case after
A week, Your Lordship.
a week. Prayer is allowed. Listed accordingly. Okay.
Your Lordship, I have similar prayer for item number 22. Your Lordship.
Okay. You are the counsel for the
Appellant, Your Lordship.
Mr. So-and-so? Yes.
I respond, I report a respond number 123 step. So next week, I have some engagement on the second. This is after 1 week. Not on the second. My,
Mr. So-and-so, the learned counsel for the appellant. 6 adjournment of the case on ninth,
Yes, Lordship.
9th, on 9/8/2023. Prayer is allowed, listed accordingly. Okay.
Much obliged. For motion, item number 23. Please, Your Lordship,
Yes.
I file my affidavit.
In which case? Motion, let's move.
This, Your Lordship.
Yes.
This application is for extension of the interim order, Your Lordship, because first, earlier, due to
But what was your interim?
it was not to, if I may, the exact word is no promotion should be given to the post of additional director of the department.
Okay.
That was the order.
Any promotion effected after the interim expired?
No.
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 Okay. What is the interim order dated?
This is 27/9/2021.
I think this matter is listed for hearing on.
2nd of August.
Okay, so we extend it.
My lord, I have objection to this IA.
So we extend it.
My lord, even on the facts.
Okay, we hear on, it's listed on 2nd. We hear everybody on 2nd. What is the interim order?
Annexure A.
Annexure A, page
A.
Page
14.
40.
41 4. 1 4. Order is at page 17. It starts from last paragraph.
said, Mother, if I will be allowed to make one sentence submission.
Yes.
Just one sentence. But when this writ petition was first filed, there was the petitioner number one was one engineer Wati. He was a joint director. And the respondent number 5, the private respondent number 5 was also a joint director. That is how the stay was passed. The interim was passed. To the effect that no one should be promoted to the post of additional director from both the wings.
Okay.
Now, when during the pendency of the writ petition, that engineer Wati, he has resigned from the post and he has left. So there is no one from the any wing to be promoted.
Let us hear you on second. Mr. Tongpok Pongoner, the learned counsel for the applicant. And who is for the government? MS AIME for the state respondents. Stop. Also heard Mr. Takakichu. You are the learned counsel for the
Respondent number 5 to 16.
respondent number, learned counsel for the respondent number so and so. This so and so. This application has been filed for extension of the interim order dated 27/10/2021 plus by the learned single judge, correct?
Yes,
On 27/10/2021. In WPC 261/2021. Stop. The parties are heard. The interim order granted by the learned single judge. Interim order dated so and so, granted by the learned single judge in WPC 261/2021 is extended till the next returnable date. Okay. So this petition will stand disposed. This
In the main petition,
this application will stand disposed. The application accordingly stands disposed.
and in the main petition also.
We have passed order, na? In the main petition, it's on second. Okay.
For admission, item number 1.
Yes, Mr.
Lordship, I filed affidavit on behalf of respondent number 3, 4, and 5.
3, 4, and let's see. Have you received, ma'am?
Yes, Your Lordship, I just received the affidavit this morning on Your
Okay.
Lordship. If I may be allowed some time to go through and then
And,
the instruction, Your Lordship.
You are for? You have not received. Whether you have filed your affidavit? You have filed your affidavit, okay. Mr. Sit- You have for respondent number? You have received the affidavit. Have you filed your affidavit? No. Mr. LT, you are for
Respondent number 4, 5, 3, 4, and 5.
3, 4, and 5. Mr. Yangarwati, you're yet to file your affidavit. Who is the man?
State and the food opportunity here. Because it is admitted in the petition also that the central government they have already supplied all the food grains.
So at least file your affidavit to that effect.
I have not received any instructions so far.
But you file your affidavit, at least to that effect. When can you file?
So far, I have not received any instructions. On several occasions, I have written to the ministry, and the last was on 22nd, 7, 2002.
Whether there's an admission on the part of the state that you have received the food grains. Okay. The affidavit filed by the state respondent number 3, 4, and 5 shall be furnished to the learned counsel for the petitioner, as well as the learned counsel for the respondent number 1 and 2. When? In the course of the day. The learned counsel for the petitioner submits that. Only after going through the affidavit filed by the state respondents. She will file the reply if necessary. Listed after?
3 weeks, Your Lordship.
3 weeks.
Right, Your Lordship.
Yes. What was the last order?
315.
Said you 1-5.
Yes, my lord.
The 160 was listed, but it was just, the case was just adjourned. The order was passed on the 31st of May. And the last portion of the order, Your Lordships, the third last paragraph. May I read the relevant portion, my lord?
Yes.
The relevant portion, third last paragraph. Yes, the affidavit dated 31/5/23, filed by the respondent number 10, has been produced, where the work completed is shown to be 32.58%. So also the affidavit filed by respondent number 9 states that 34.29% of the work has been completed. So the respondent number 9 and 10 shall on the next date fixed file a detailed affidavit showing the progress of the work on the existing ROW. On the remaining land required for the construction of the said work, Union of India, the respondent number 1 shall immediately take steps for acquisition of the land as provided under Section 3 of the Highways Act 6. All steps taken by the respondent number 1, that is the Union of India under Section 3 of the National Highways Act 1956, shall be placed before this court by way of an affidavit on the next date fixed. So this is the only option. Now, an affidavit has been filed this morning by the NHIDCL, the respondents 1 and 2. This morning, an affidavit has been filed. Whether that is before your lordships.
So two things are relevant. That is on the progress of the road
Yes.
and the acquisition of the land. Okay. So first, let's see progress.
Some affidavits have been filed this morning, lordships. So are they before your lordships? One has been filed by the authority engineer, and one has been filed by the respondents 1 and 2. This morning.
26 July.
Yes, madam. Yes.
Respondent number 9. Respondent number 9 is? Who is 9?
Respondent number 9 is a contractor.
Also contractor.
Contractor has also filed.
Okay.
And the authority engineer has filed his affidavit.
What is your progress? Let's go one by one. What is your progress, Mr. Joshua? And what is the position in the Supreme Court?
From the 11th of September.
Yes, Lord.
Okay.
Next date is 11th of September.
What is your progress?
Lordship, as on day,
42.
progress is 42.22.
When was the last order passed? 31.5.
I wrote the last.
And whether the NIDCL is in agreement with this? Who is for the NIDCL?
NHIDCL.
NHIDCL, I'm sorry.
Lordship.
Whether you are in agreement with this,
Yes, Lordship.
that the progress of the work
Yes,
is 42?
The authority engineer has filed the affidavit, so Lordship is more or less the same, Lordship.
Okay. But Mr. Joshua, you seems to be very slow.
Lordship, as far
As per the last order, you had actually stated that you had completed 34.29% of the work.
Yes, Lordship.
Today, your affidavit says only 42.22.
My Lord, in the last 1 month, we've not been able to do much work because of the inclement weather, but
That is again the excuse. For the last so many years, you are giving that excuse. When the rain comes, you say it's because of when the monsoon comes, it's because of the rain. When the winter comes, it's because of the cold.
all my lords are fully aware of the history of the case, especially your lordship, that as far as the protection given by the Zombie Court, after that, we were expecting that we would be able to work smoothly. There has been some communication gap between the NHIDCL and us, the contractor, which led to a delay in work in the season when we could have worked the most.
The Honorable Supreme Court has stated only the timeline given by this court. Correct?
Yes, lordship.
Correct.
Yes, lordship.
We are still not debarred from imposing cost. Please take note of that.
My lord.
We'll impose cost if the work is slow. We'll penalize you.
As far as this last 1 month is concerned, your lordship is fully aware of the situation even in a 4-lane road also, lordship.
You are not responsibly discharging your work and you blame everything on.
If my lords may kindly appreciate this fact. After the second intervention of this Honorable Court, we've been able to work only after that, peacefully, without having any misunderstanding with the NHIDCL.
If you're actually in that position, I think your progress should have been much better.
No, lordship, my lord is aware of the weather condition now. I mean, when the heavy rainfall is there, Impossible to execute any work.
You are giving very good excuse, but that does not convince us. Next time we will see, and we make it very sure that we will impose substantial cost if the progress of the work is slow. We will impose substantial cost. We are reminding you again and again. Please take note. Tell your contractor. We are not going to spare you. The Honorable Supreme Court has actually stated the time limit given by this court for completion of the work. But that doesn't mean that this court cannot impose cost for your laxity. Please take note of that. Yes, and what about the other one, the other condition, the central government?
Lordship, may kindly turn to the affidavit which I filed.
Yes, which is the affidavit?
Filed by respondent number 128.
This is the affidavit. And what about the affidavit filed by NHIDCL?
128, Lordship. Yes, Lordship.
This is affidavit respondent number 10. Who is for respondent 10?
Authority engineer.
Authority engineer. Okay. What about
Direction to the Madras Honorable Court to me is to file an affidavit pressing on report with progress of that number. That that is the immediate direction. From that.
where have you stated that? Progress is 41.21. Okay. No. Affidavit 120. Why all this affidavit? Oh, this is in a bunch. Yes, Mr. Moa, what is your affidavit? This is dated 25 July.
Lordship.
Okay.
Lordship, may kindly turn to page 6, Lordship. Page 6. Lordship, spotted, Lordship.
Page.
6, Lordship.
Yes.
This is a communication dated 26th May 2023, Lordship.
Yes.
This is written by the Executive Director, NHIDCL Headquarter, Lordship, Delhi, Lordship. Now, this is addressed to the Principal Secretary to Chief Minister. Second is Senior PS to Deputy CM and Minister in charge of National Highways. Third is the Deputy Secretary to Chief Secretary Nagaland, and the fourth is Executive Director P, that is RO Kohima, Lordship. Now, the subject pertains to record of discussion held during the meeting of Managing Director, NHIDCL, with Honorable CM, Deputy CM, and Minister in charge, National Highways, and Chief Secretary Government of Nagaland on 10th of May 2023. Sir, your kind attention is drawn to the letter under reference, which the record of discussion held during the meeting of MP and NHIDCL with Honorable CM, Deputy CM, and Minister in charge, National Highways, and Chief Secretary Government of Nagaland on the 10th of May 2023 was forwarded. We're concerned with the fifth point. Lordship will find it the page 7, Lordship, the fifth point, Lordships.
Yes.
Kohima Mao, Lordship. Fifth point. It is mentioned that due to exorbitant rates of damage compensation, the BAFE shelter has been de-scoped from the present scope of the contract. Accordingly, the EPC contractor was directed to construct a road within the existing ROW. NHIDCL is of the opinion that in densely populated towns to avoid relocation, displacement of public in large number. Generally, it will be beneficial if the town is bypassed. As stated above, the revised cost compensation for this stretch may not be required. So
What does it convey?
it conveys that there was a discussion with the representative of the state as well as the NHIDCL. Now the road has to be constructed only on the existing road logic, and no acquisition may not be required. That is the decision logic taken by the state as well as the NHIDCL logic.
So this is between which stretch?
Logic.
This is between which stretch?
Logic, it is for the entire project logic, Kohima to Mao logic.
Kohima to Mao.
Yes, logic. It has also discussed about some other projects logic which is not relevant in this.
No. Kohima Mao.
Kohima Mao logic. The present PIL logic.
What do you mean by the brave soldier has been
Descoped.
descoped? What do you mean by that?
Logic, the
In a layman's language?
logic, the road has to be constructed on 7-meter logic, and the beam shoulder is 1 meter on both sides logic. So it has been descoped due to non-availability of land, and also for the reason that there is exorbitant rates of damage compensation logic. So the decision has been taken by the representative of the NHIDCL, that is the managing director of NHIDCL from Delhi logic headquarters, and also in the presence of the CM, deputy CM, and also the chief secretary of the state logic. This is a unanimous decision of all the representative logic.
So you will not be acquiring land,
Logic.
and you will be constructing only within the ROW.
Logic.
Yes, Mr. Ejimom, I think we cannot go beyond that.
No, my lord. The point is this: this clause, this letter, which my other friend is referring to, this is in relation to the specific direction given on 315. But your worships will recall, direction given by this honorable court is that construct on the existing road, and the remainder you construct after acquisition.
Yes, that is there, but
So now, therefore, my lords, whether the NHIDCL and the state and the union can, by this executive decision, overcome the judicial order of the honorable court, it's as simple as that, my lords. And the further point which your lordships may note is this, and that is the most important point. Right from the very inception, work should have started by resort to the provisions of the National Highways Act. And in terms of the National Highways Act, the Land Acquisition Act. Now they're referring to damage compensation. How did they assess damage compensation? By not following the law. That is why we are in this problem.
say, Mr. Ejimomi, something has gone horribly wrong, but now at this stage we cannot undo it. That is the issue.
Your Lordship, this court is in session of the matter. A national highway has been declared. It is the duty of the central government to acquire the land, to build, operate, construct, and maintain.
Okay, we have taken your submission into consideration. We will pass necessary orders.
Kindly
After
record my
discussion.
submission.
Yes, we have
My
taken.
lord, as the amicus curiae appointed by this honorable court, if I don't place this the legal provision before this honorable court, I will be failing in my duty.
We have taken note, Mr. Ejimomi.
Very well.
Yes, in the chamber.
For admission, item number
Yes.
Please, my lordship, this is prepared months of last for an act to the challenging of the granting of bail to the accused persons. My lordship, therefore, the respondent already filed their affidavit. My lordship, therefore, can you please admit the petition to take for final hearing?
Yes, Mr. Jimomi.
Fixed hearing.
On 9th, my lordship,
9th of August.
9th of August.
The written objection is filed by you.
I have filed it. And I have filed it on the 7th of September last year. From then, they've been taking time to file a rejoinder, but they have not filed any rejoinder till now.
You file your rejoinder.
Not filed, my lordship.
You are not filing.
But I am not, I only last week only I have to receive the information from headquarters to attend.
So whether you are filing any reply.
No, my lordship. Therefore, I have to be directly and hear the matter. My lordship.
It's not
Okay.
filing it.
Okay. Okay.
Otherwise, it will be again taken adjournment. It is not. It is already more time. It is possible.
Okay. Okay. There's only one respondent accused.
My lordship, two appeals.
No, two, but in this appeal, only one respondent. Okay. Third, Mr.
Satyanand Senior will be an
So and so, learned senior counsel, learned
Senior PP and
Senior-
senior PP NIA, and Mr. A. Jimomi, the learned counsel for the respondent accused. So it is submitted by the parties that pleadings are completed, and therefore the matter can be taken up for hearing. Listed for hearing on
9th of August.
9th.
9/8/2023.
Same order in the next
Same.
year.
Connect.
In which item?
The next item.
Next item.
Item 4. Item 4. Same order. Item 4. Okay.
Yes.
Okay.
Much
Okay.
better.
For admission, item number 5.
My lordship, she was filed appeal under section 21 of the class report. My lordship, granting of bail to the one of the accused who are the main accused in this.
What is your IA? Learned counsel.
My lordship, IA is the condonation of delay for 9 days.
Has it been condoned?
Even my lordship,
Has it been condoned?
made it now, my lordship.
Has it been condoned?
But respondent,
See, yeah, you forget about the respondent.
notice
You
already.
read your file and come.
Sorry, my lordship, respondent already last time you take the justice service and.
Who is for the respondent?
Respondent is the account number 8 here in my lordship. Respondent number is
MS Vicotsonyo. MS Vicotsonyo. MS. Yes, Mr. Lucino. I think this also is Mr. A. Jimomi.
no, it's not connected.
His junior is there.
Maybe but some other counsel is appearing in trial court.
Ms. Lucino appears on behalf of the respondent.
also filed my lawsuit. I'm setting up the opponent to the notice on 23 February 2023. The NIA constable one.
Has any order been passed in regard to your application regarding condonation of delay? Not passed. Yes, ma'am. Item,
Should we are appearing in item number 3 and 4, not in 5.
no, because actually the name of Madam Lucino is reflected in the order in this case. Lucino, you are Lucino?
Lordship,
Yes, your name is reflected here, and then one MS Vicotono. Her name is also reflected on two different dates. On 19/4/2023, your name has been reflected, and 17/5/2023, Vicotono.
I think there has been a confusion because usually all these matters, they are listed on the same day, Lordship.
And who is Madam Vicotono?
She's also here.
You are appearing in this case. So why your names are reflected? I think you were eager to reflect your name.
Lordship, usually all these matters, they are being listed
Ah.
on the same day, Lordship. So I think there has been a confusion, Lordship. We are appearing in criminal appeal number 3
Yes.
of 2022 and criminal appeal 4 of 2022, Lordship.
The two cases listed before this.
Yes, Lordship.
Yes,
So we are
okay.
appearing in those two.
Okay. I thought since your name is reflected, I think you must have overlooked. Okay. Okay, so what was the last order passed in this? This 9/5. Prayer for dinner. Oh, private respondent is yet to enter appearance. So what do we do?
Notice already served to the person.
Who is that person?
That is the accused Sema. He is the accused number 8 here.
He is
Accused number 8 here is the respondent one. My lordship. Accused Sema. Accused Sema.
he is the sole respondent.
He is the sole respondent here.
Yes, but he is the accused number 8 in the trial case. So what do we do? Where is his address? How have you given his address?
Already my officer has served to him when he is appearing in the trial court. He is already affidavit also may not file in his.
You have filed affidavit?
May please do. February 23 it is.
You have filed affidavit?
May please do.
Okay. Your affidavit is 23?
23 February 23.
Okay.
For serving of notice to respondent. Justice service may not. Arbitrated on 15 December 22.
No. The notice has been served only to the council. So we never know whether the council has actually served the notice to this respondent. You see the paragraph 3, brother?
From the council, yes.
So we never know.
On that day, as appeared before the court, therefore, otherwise, may not kindly issue notice to the respondent, then we will take further steps. That will be the justice service may not.
You take steps for substitute publication? Can you? Paper publication? Okay.
Both justice service as well as paper publication, both we may.
Dusty.
Mail ID.
Dusty service also?
Dusty service. Dusty as well as paper service, both subscripted service.
Okay.
That is a better for serving notice.
Okay. Mr. So-and-so, you are learned
Senior PP.
senior PP for the NIA. For the NIA. Okay. Stop. We have perused the affidavit. Dated 23/2/2023. Filed by Sri Wapang Temse, Constable, Court Pairavi. What is Court Pairavi? Okay. Officer, NIA Branch Office, Imphal, Manipur. Stating that he has served the notice issued on 8/12/2022 to Sri Atoshe Sema, within bracket A-8, accused 8, okay. A8, close bracket, son of Zuhusha, Zuhusha, Sema, resident of Alaphu, Alaphu, Alaphu village, Zineboto, Nagaland. Through his counsel, Srimati Esther, ESTHERKIA, on 15/12/2022. Stop. By this affidavit, we are unable to ascertain as to whether the notice issued by this court has been served on upon Mr. Atoshe, the respondent in the present case, by his learned counsel. So, in that view of the matter, we deem it proper that the learned counsel for the NIA shall take steps for service of notice upon the respondent, upon the sole respondent, okay, by dusty process as well as by paper publication.
And that's it.
The the learned counsel for the NIA shall take steps for service of notice by dusty process within a period of when can how within how many days can you take steps for dusty service?
The max is on 20 August it is there. Therefore, until this the present date, therefore we have to be serving justice service, and also immediately within the 1 week we have to make state paper publication.
Within a period of 7 days.
7 days paper publication.
Within a period of what was that? Within a period of 7 days.
Justice service is 23 date is fixed, my lordship. On that day is appearing before the court. On that day is served. But paper publication should be taken within the 7 days.
How are you convinced that he will appear before the court on 23rd?
Matter is there in regular trial court, my lordship. On that. The trial matter is there on 26 August, my lordship.
So, so we cannot allow you to serve dusty, only paper publication. You are saying that you will serve dusty this notice when he appears before the lower court, trial court. No, that's not possible. What was the last?
My lordship passed, my lordship, justice service and to be instructed to my SP to commission to take.
You take dusty service within 7 days. What was that? Within a period of 7 days from today, and the notice by paper publication shall be published within a period of 10 days from today. The notice shall be published in one of the local dailies having wide circulation in the state of Nagaland. The learned counsel for the NIA shall thereafter file an affidavit stating service of notice by dusty as well as by paper publication. Listed
On 6th of September, my lordship.
listed on 6/9/2023. Okay.
For admission, item numbers 6 to 8.
Please, Lordships.
Yes.
My Lord, in item number 6, 22 WPC 222, where you have filed affidavit in reply to the
WPC
item number 6.
Item 6222.
My Lord,
You have for respondent number?
where the petitioners, my Lord.
Oh, you are yet to file affidavit in reply.
My Lord.
To whose affidavit?
To the affidavit of the respondent number 2, 4, and 5.
And for the department.
Okay. What about the other items?
My
2,
lord,
3, 2?
Item number 7 and 8, pleading is completed, madam.
Item number 7 and 8.
7 and 8.
Yes, Mr. Wati, any submission? You are for, okay, pleadings complete. You filed your affidavit? Okay, and 8, what about 8?
7 and 8, but
Okay, you are not in 8. 8 complete, complete. So it is only with regard to item 6,
6, my lord.
correct?
My lord.
Okay. Mr. So-and-so, the learned counsel for the petitioner submits that. For the petitioner, sorry, the learned counsel for the petitioner in WPC 222/2022 submits that he may be allowed, how much?
3 weeks time, my lord.
He may be allowed 3 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondent number 2, 4, and 5. Prayer is allowed, listed after 3 weeks. Okay.
Much obliged, my lord.
For admission, item number 9.
For admission? Why? What is this? Why this admission for item 9? Oh, we are 8. We're finished 8.
Yeah.
Okay. Yes.
Yes,
Yes.
Nepalese lordships. Lordship, this is a habeas corpus matter. And I'm challenging the detention order passed by the Special Secretary to the Government of Nagaland
Okay.
under Section 3.1, it's NDPS, 1980.
Okay.
The brief facts of the case is that on 21 or 24th of January 2023, the police personnel, along with crime branch, has raided the residence of the detainee and arrested him on allegation of the suspected narcotics arms was recovered from his residence. And accordingly, an FIR has been registered on the same day. And under Section 21,
I think notice has to be issued and the records has to be produced. What do you say?
I filed the affidavit.
Have you filed the affidavit?
Yes, sir.
Okay. What about the records?
What about Union? Yes.
Records?
Records are, it's already here.
Has notice has been issued? Has the notice issued?
For the records.
No. Formal notice has been issued.
also, yes, notice has been completed and pleadings have been completed.
Okay. In that case, I think we will have to call for the records. Do you have the records? Okay. Are you ready? Okay.
When the detainee was on judicial and he was sent to judicial custody on 2nd of February 2023. And when the detainee was under judicial custody, the additional DGP has brought a proposal letter for detention to the Special Secretary. And based on the proposal for detention by the additional DGP, the special secretary has passed a detention order against the detention. And being agreed, I have submitted the representation, but my representation was also rejected. So I have come before this honorable court to set aside my detention order as well as the confirmation order passed by the advisory board. I'm challenging the detention order on two grounds. The first ground is the detaining authority, while passing the detention order, passed mechanically, thus placing on the proposal letter sent by the additional AGP, and without any application of mine, and without any subjective satisfaction. It is a settled principle that when a person is in a judicial custody, the authority who is passing the detention order must first acknowledge and reflect in his order the fact that the person intended to be detained is under judicial custody, and there are reasonable and urgent reasons to believe that the detainee may act prejudicial if released on bail. However, such justification was not mentioned and reflected in the detention order. And moreover, the affidavit filed by the detaining authority, para 8, para 8, page 5. Para 8, page 5. Second para, accordingly, the purpose of such skill check by established facts and circumstances of the case was forwarded to the detaining authority. The FIR and the police report are valid documents containing the actual facts and circumstances of the case. The ground of detention has been formulated by the detaining authority in line with the established facts and circumstances of the case. It is pertinent to mention that the detaining authority, while considering the detention of the detainee, under A, had written letter number so and so dated 17/2/2023 to the sponsoring authority to ascertain the fact as to whether the accused person, namely Mr. Rokotiko has moved bail application in the country court or already enlarged on bail as on that. And in reply to that letter, the right letter number dated 17/2/2023 in this regard was received from the sponsoring authority on 18/2/2023, informing that the detainee has not applied for bail in India. Having satisfied that the detainee was still under judicial custody in jail, Kohima, the special secretary of past the detention order, also, the detaining authority, knowing that before the passing of the detention order, the detainee was already in judicial custody and he has never applied for bail, and no bail application was pending before the court. In spite of knowing that, while passing the detention order, because if there was no bail application pending before the court, then the detaining authority having the apprehension that the detainee is likely to be released on bail, and it is necessary that the detainee should be passed detention order in order to restrain him to act prejudicial for the safety and security of the state. But in spite of knowing that no bail applications filed, the detaining authority has passed the detention order. And even the detention order, they have not stated the fact that no bail application was pending. And if no bail application was pending, there is likelihood that the detainee in the near future will file a bail application and is likely to be released on that. That was not reflected and mentioned in the detention order. As such, the detention order is likely to be project. And in support of my discourse, I would like to place judgment passed in Supreme Court. Oidrum Konu Chao Singh versus State of Manipur and others. The relevant para is paragraph 9 note. I made a paragraph 9. In view of the above, it can be held that there is no obligation in law to pass the detention order in respect of a person who is already in custody in respect of criminal case. However, if the detention order is challenged, the detaining authority has to specify for the following facts. The authority was fully aware of the fact that the detainee was actually in custody. There was reliable material before a said authority, on the basis of which we could have reasons to believe that there was real possibility of his release on bail. Now, further, on being released, he will probably indulge activities which are prejudicial to public order. In view of the above, the authority felt it necessary to prevent him from indulging in such activities, and therefore detention order was necessary. In case either of these effects does not exist, the detention order would stand by the dictator.
Appreciate this.
My second ground is there has been unreasonable and unexplained delay of disposing the representation of the detainee by the state government for 16 days and by the central government for 66 days. Worship, the detainee has submitted his representation on 13th of March 2023, and the same was received and forwarded by the Superintendent of Jail Dimapur, Central Jail Dimapur, to the state as well as the central government. Whereas the state disposed the detainee representation only on 24/3/2023 and was served to the detainee.
Representation on?
Received disposed the representation by the state government.
No, when it was received.
On 13th.
30.
Yes, 13th of March.
Hmm.
And on this
1-3, 1-3 or 3-0?
1-3.
1-3. Okay. Hmm.
And on the same day, the Superintendent Central Jail Dimapur has forwarded to the central as well as to the state government on the same day. And the state government disposed the representation of the detainee only on 24th of March 2023.
Which para have you stated that?
Worship, my grounds, Roman 2.
Age?
Page 8. State has disposed the representation of the detainee on 24th of March 2023. However, it was served to the detainee that his representation has been rejected only on 28th of March 2023. And as such, there has been unreasonable and unexplained inordinate delay of 16 days in considering the representation submitted by the detainee. And whereas the central government has taken 66 days to dispose the representation of the detainee and disposed only on 16th of May 2023 and it was served to the detainee on 17th of May 2023. And as such,
Where have you stated all this?
yes, after all
No, in which para? In
page,
which paragraph of your petition?
page 8 in my grounds, there is Roman letter 2,
Page
page 8.
this Roman.
Roman 2 grounds.
Something is wrong with your petition.
Para 9,
Something is wrong with your petition. The paging in my brother's file and my file is quite different. What is your page 8? Read your page 8.
page 8, Roman 2, that the detainee submitted his representation.
No. That is not there in my page. Oh, that's why I'm sorry. Okay, read petition. Page 8. Okay. Yes.
Such the inordinate delay of 16 days by the state government and 66 days by the central government has made the continued detention of the detainee illegal, and which is clearly in violation of Article 22(5) of the Constitution of India. Also, in support of my second ground, I would like to place some judgment. Babu Hamid versus the Union of India and 5 others. The relevant para is para 9, 10, and 11. Para 9, 10, and 11. I need a lot of the law in this respect has been settled by the Honorable Supreme Court in its pronouncement in Rashid Kapadai versus Meda Kadhi and others, reported in 2012-11 SEC. It is well settled that the right of a person who is preventively detained to make a representation and have it considered by the authority concerned as expeditiously as possible is a constitutional right under Article 22(5). Any unreasonable and unexplained delay in considering the representation is held to be fatal to the continued detention of the detainee. The proposition is too well settled in a long line of decision of this court. We do not think it necessary to examine the authorities on this aspect, except to take note of a couple of judgments where a principle is discussed in detail. Para 10, a reading of the aforesaid provision of Honorable Supreme Court in Rashid Kapadai Supra makes it discernible that when a detainee under preventive detention makes a representation, it has to be considered by the authority concerned as expeditiously as possible, as it is a constitutional right under Article 22(5) of the Constitution of India, and any unreasonable and unacceptable delay in considering the representation would have to be held to be fatal to the continued detention of the detainee. Part 11. In the matter that was before the Honorable Supreme Court in Rashid Kapadai Supra, There, the authorities took about 1 month to dispose of the representation of the detainee concerned. And even the period of 1 month taken by the authority to dispose of the representation was viewed by the Honorable Supreme Court to be beyond the expeditious disposal as required in the case of the preventive detention. Also here, the Honorable Supreme Court observed that even the period taken to dispose of the representation for 1 month has been delayed. And whereas in my case, the central government has took more than 2 months, and the state is 16 days. And Lordship, another in Divarshi Kashyap versus the Union of India and 7 others. The relevant para is at page 8. Page 8. I did para 12.7. Page 8, para 12.7. In Nipro Pro Supra, 2 months delay in disposal of representation submitted by the detainee was held unacceptable by the division bench. It was held that unexplained delay in disposal of representation of the detainee was violative of constitutional guarantee under Article 22(5), having a right to reflect on the order of detention. And similar view was expressed in Nala Paitri Supra, wherein a division bench of this court had set aside the order of detention on the ground of one of satisfactory explanation for the delay of 17 days in disposal of the representation of the detainee. And what should given here, even the delay for 17 days, the court has observed. Resting on these two grounds, I'm approaching this honorable court to set aside my detention order.
According to you, within how many days it has to be disposed of?
As per Article 22(5), it's not mentioned, but as when the state and the central
That's why I'm asking. We are asking.
have received
According to you, why you are saying there's a 16 days delay and 66 days delay?
Lordship, because I have submitted my representation on 13th.
Yes.
And on the very day, on 13th, the Superintendent Jail, Central Jail Dimapur,
Yes.
has forwarded to the state as well as the central my representation. So, what had taken both the state as well as the center so long to dispose my representation?
No, that's why we're asking what is the reasonable period the representation is supposed to be disposed of?
Reasonable? As per the Honorable Supreme Court, even 17 days.
No, forget
they have
that.
considered-
That we have seen it.
Yes. Might be within 10 days or 15 days.
According to you.
Yes.
Just saying that there's an unreasonable delay will not be suffice. You will have to show that these are the reasonable period. You are not sure. You say it's reasonable, could be 10 days or 15 days. How do we?
So, as per Article 52(5) is also stated the concerned authority, the detaining authority, as well
Within reasonable time.
Yes, to dispose the representation expeditiously
No, that's why we are asking according to you.
without delay.
What is the reasonable period?
15 days now. And even if the state have disposed the representation on time, so the central government, it took more than 2 months, 66.
any definition on the reasonable? The word reasonable,
Yes.
about that, do you have any judgment?
The time,
There is a judgment of the Supreme Court.
the time taken to
What
travel
is-
from Dimapur Central Jail to Kohima is only 1.5 hours. So, from the day I have submitted the representation, the state government, that is the detaining authority, have received my representation. So, they have taken 16 days to dispose my representation. So, they have to explain. If there is delay, then they have to explain in the affidavit. This is the reason, this is the reason that the representation of the detainee was delayed for this while considering.
Yes, the state.
Against the two grounds, Your Lordship.
Yes.
I have replied, Your Lordship. Uh,
1, 2, 3. Affidavit by 1, 2, 3.
Yes, Your Lordship, on behalf of
Yes.
Your Lordship's letter. Find Your Lordship, which the petitioner has already read out, Your Lordship, answer for the petitioner, Your Lordship. With regard to having in their petition, they have stated that they had not acknowledged that whether the petitioner had taken bail or not, Your Lordship, which in fact is clearly stated in detention, grounds of detention. I'll just read out Your Lordship. Page number 5, starting from para 11, Your Lordship. A reply writes,
Who's your para 11 in page 5?
sorry, Your Lordship, sentence 11. Your Lordship, I found.
A reply.
Yes, sir. A reply by the such and such, in this regard was received from sponsoring authority on such and such, informing that the detainee was not, has not applied for bail within bail. Having satisfied that the detainee was still under judicial custody in district Kohima, the special secretary of passed the detention order dated such and such against him. Accordingly, the fact that the detaining authority was aware that the detainee was in judicial custody at the time of passing the detention order dated such and such.
A little slow. Don't rush things. Slow. We are not getting what you are reading.
Is reflected in ground number 4 of the grounds of detention communicated to the detainee, Your Lordship. In grounds of detention, Your Lordship, ground number 4, it's clearly stated, Your Lordship. The grounds of detention is annexed in the petitioner's writ petition. Page 22, Your Lordship. Ground 4, ground 4, Your Lordship. 28, Your Lordship, of the petitioner's writ petition, page 24, annexure
24 or 28?
page 28, paragraph 4, Your Lordship. If I may read, Your Lordship. Upon Your Lordship, page 28 of the writ petition, paragraph 4, Your Lordship. That you are presently under judicial custody with effect on such and such. On the basis of material placed before me, I am satisfied that you are likely to indulge in similar prejudicial activities unless you are prevented from doing so by an appropriate order of preventive detention. Taking into account the nature of your antecedent activities, it is likely that your release from custody you will indulge in prejudicial activities, and it is necessary to detain you in order to prevent you from engaging in such activities, Your Lordship. This was clearly stated in the ground of detention, Your Lordship. Their allegation is that we were not aware whether he was in judicial custody or not, Your Lordship. That is wrong, Your Lordship, because it's clearly stated in the detention order that we were aware of the fact that he was in judicial custody. And Your Lordship, in support of my paragraph, the relevant paragraphs are 13, 14, and 17, Your Lordship. If I may read, Your Lordship. Paragraph 13. In a series of decisions, this court has held that it is the subjective satisfaction of the detaining authority whether a person has to be detained for a particular period of time or not. In the impugned grounds of detention, the detaining authority has narrated all the reasons for passing the detention order detaining the appellant with a view to prevent him from abating the smuggling of goods in future. With regard to non-application of mine, Mr. K.K. Mani, learned counsel for the appellant, pointed out that on the day of passing such and such detention order on such and such date, the detainee was in prison, though he was granted bail on such and such. He had not availed the same and continued in prison on the date of the order. According to him, this aspect was not reflected in the detention order, which, according to him, vitiates the detention on the principle of non-application of mine, Your Lordship. It is true that though the detainee was granted bail on such and such, for the reason best known to him, he did not avail such benefit and continued to be in jail on the date of detention order such and such. It is true that this aspect has not been mentioned in detention order. However, on the ground, however, on the other hand, it is not in dispute that the grounds of detention, which form part of the detention order such and such, clearly mention the details about the bail order such and such, and non-availing of the same on the date of detention order such and such, Your Lordship. And paragraph 17, Your Lordship. For the same reason, the other contention, namely that there is no compelling necessity to pass the order of detention, is to be rejected. As a matter of fact, the learned counsel for the detaining authority took us through various ground details, materials adverted to in the impugned order, and we are satisfied that it cannot be claimed that there was no compelling necessity to pass order of detention. We have already pointed out that it is the subjective satisfaction, Your Lordship, of the detaining authority whether an order of detention is to be invoked or not. Accordingly, we reject the above contention. Your Lordship, with regard to the non-application of mine in passing this order, Your Lordship, particularly with regard to non-availing bail, Your Lordship, the detaining authority was conscious of all relevant aspects and passed the order, Your Lordship, in order to detain the detainee from abating prejudicial activities, Your Lordship. And Your Lordship, with regard to ground number 2, on ground of delay, Your Lordship, there is it's page number 6, Your Lordship, of my affidavit, of my counter affidavit.
Page 6.
Page 6, Your Lordship. I would like to read para 8b, Your Lordship. The averment made in ground 10.2 of the writ petition is denied by the answering respondent. The answering deponent states that, as per record of this office, the representation dated 13/3/2023 was received by the detaining authority by India Post on 23/3/2023, and forwarded to the concerned jail authority, which was put up for consideration of the detaining authority on 24/3/2023. The detaining authority, that is the Special Secretary Home, carefully examined the points raised in the representation and found no merit in the representation, turned it down. The detainee was accordingly informed by Order 24/3/2023. Again, the representation dated 13/3/2023 addressed to the Chief Secretary on received by the Home Department was put up for consideration of the state government on 27/3/2023. The state government authority examined the points raised in the representation in all relevant records, including the materials by which the Special Secretary Home was satisfied to direct detention of the detainee was examined. Accordingly, having found no merit in the representation, the state government authority turned it down. The detainee was accordingly informed by order such and such. As such, there was no delay in disposing the representation submitted by the detainee from the date of receipt of the same, either by the detaining authority or the state government. And also, Your Lordship, para 8C, page 7. The amendment made in ground 10.3 of the writ petition is a submission of the petitioner. As per record of this office, the case of the detainee was forwarded to the PITNDPS Advisory Board on 4/3/2023 for its independent examination. The board, after personally hearing the detainee and after taking into consideration the facts and circumstances of the case, found sufficient cause for detention of the detainee in its report dated such and such submitted to the state government. Accordingly, confirmation order of detention dated such and such was issued on the basis of board's report submitted to the state government, wherein the detention period of the detainee was extended for another period of 3 months with effect from 25/5/2023 to 21/8/2023. Your Lordship, the detention order was, let me go to the facts, Your Lordship. The representation was received on, the state respondent received it on 23/3/2023, Your Lordship. And 24/3/2023, the representation was rejected, Your Lordship. And the same was sent to the advisory board on 4/3/2023, Your Lordship, within 10 days, Your Lordship. It was referred after the representation was rejected, Your Lordship. His case was referred to the advisory board on 4/3/2023, Your Lordship, within a period of 10 days, Your Lordship. And after the report of the advisory board was received on 1/5/2023, Your Lordship, the confirmation order was issued on 9/5/2023, Your Lordship. And Your Lordship, if I would also like to refer to the PINTDPS Act, Your Lordship.
Your paragraph 8C, case of detainee was forwarded to advisory board on 4/3.
Yes,
What
sir.
does it mean?
Yes, Your Lordship.
4/3,
Yes. For its
4th of March.
Yes, Your Lordship.
Advisory was before the, it was sent before the disposal of the representation.
The representation.
Representation was disposed of on 24.
Yes, Your Lordship.
Oh, no.
On 24/3, representation was rejected, Your Lordship. The
Then
day of the representation.
what about this 4/3 advisory board?
The case was referred to advisory board, Your Lordship, for confirmation, Your Lordship.
On 4/3.
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
Before rejection of the representation.
Yes, Your Lordship.
There is something wrong with your date. You see your 8B and 8C. Just don't blindly read.
Oh, yes, Your Lordship. Before the representation was disposed, Your Lordship, the case was referred to the advisory board.
When was your the detention order? When was the detention? What detention order? Date of detention? Detention order.
Second
22nd.
of February 2022.
Madam, is it your case that after the detention order was passed, it was sent for confirmation on 4th of March? Is it your case?
Your Lordship, let me fix
I think
this system.
she was attended also. The detention order February. Or March. I think after the detention order was passed, then for confirmation it was sent.
Yes,
And then finally it was heard on 1st of May and then confirmed on 9th of May.
yes, the report was received on 1st of May,
Yes.
and the confirmation order was issued on 9th.
So what do you mean by saying that, according to you, is it after the detention, it has no got connection with the disposal of the representation? Is it your case?
Even the confirmation order was passed before a representation was disposed by the central government. Only after the confirmation order was passed, the central government.
Anyway, we'll come back to it. We'll just here.
The representation was disposed and it was rejected on 24/3/2023, Your Lordship.
That we have seen. What about this 4th of March?
On 4th of March, we had sent it to the advisory board, Your Lordship.
Before,
This case for consideration.
before representation.
After the representation.
No, yeah. No.
The representation was submitted on 13/3/2023, Your Lordship.
And this 4th of March is what? Fourth of March is for confirmation to the advisory board.
Yes, Your Lordship.
Are you sure?
Madam, it seems you are not well prepared to argue the case. The flipping of your petition itself shows that. We'll hear you tomorrow. Please come prepared.
Yes, Your Lordship.
Read and then come.
Yes, Your Lordship.
And my brother has some confusion with the dates. So kindly
Yes,
clarify.
I'll clarify, Your Lordship.
Yes, on that 4th March.
4th March.
Correct. Kindly clarify on
Yes, Your
that.
Lordship, my apologies.
Okay.
Yes, Your Lordship.
Come prepared. Tomorrow, first hour. Okay? We'll hear it tomorrow.
This confirmation, sending it for confirmation is one thing. It goes separately.
Correct.
And disposal of the representation is a separate issue.
Separate.
So what he's saying that confirmation is not on the confirmation. What he's saying is you have there is a delay, unreasonable delay in disposal of the representation by the state as well as the union. Appeal also. So that you have to.
Yes, Your Lordship.
No. Yes. Come prepared. Okay. And Mr. Leonard CGC, you also come prepared to satisfy this court as to why there was as per his argument, the 66 days delay. Okay, very good, very good. So come prepared. Come prepared.
I think hopefully you are aware of that confirmation also about port march. You have, of course, it's see who has to explain, but then you must be having the knowledge and idea of this the confirmation and disposal of the representation. Look into it and be clear about it. That's it.
Yes. Okay. Pass over 40. Okay. Pardon? As a part heard item. As a part heard item. Pass over 40 as a part heard item. Okay. Maybe you to list this as the first item. Okay.